A question of that nature. You spoke of the 28 visa waiver countries, and in your written testimony, at least, you speak to the fact that there is a great deal of theft of passports from those countries. And of course, those are, in a sense, valid passports. Is there any practical solution to that problem? Obviously, from very friendly countries, a visa waiver is probably a good policy decision. But how do we prevent the misuse of visa waiver passports?
I think there are several ways to do that. One is to ensure that those countries have better accountability of their passports. And if their passports are being stolen, we might want to look to see whether those countries should remain in the visa waiver program. Secondly, once those passports are stolen, they have to be reported so that the numbers of those passports can be entered into lookout systems. And when someone traveling with that passport shows up at a port of entry, an INS inspector can check the database, see that it's a stolen passport, see that it's illegitimate, and stop that person. What we found in our reviews is that foreign countries sometimes...
How are we going to determine whether the passport was stolen?
By the foreign country having clear internal controls about the passports. They know they're missing, they know they're stolen, they report it to the United States, it's entered into a lookout system, and then we can stop the people who try and use those passports. And that's what happens, but we found that it's not happening on a consistent basis, and in some cases, the INS inspectors didn't even check the lookout systems to determine whether the passport had been reported as stolen. That's one thing that we can do.
Joint inquiry reviewed passport and visa histories of the 19 hijackers involved in the September 11 attacks to determine whether they entered the United States legally. It also sought to determine whether there were anomalies in the visa process that might have alerted the U.S. government officials to the hijackers in some way. Over 10 million applications for visas to enter the United States are received each year at approximately 250 consular locations around the world. Consular officers at posts abroad review all applications and interview selected applicants to determine whether they are likely to return to countries of origin in accordance with the visa or are suspected of criminal or terrorist activities. Consular officers must certify in writing that they have checked applicant names against the State Department's watch list. Although there were anomalies and mistakes on some of the hijackers' visa applications, consular affair experts at the State Department contended in joint inquiry interviews that these errors were routine. By contrast, an October 2002 review by the General Accounting Office concluded that the omissions and inconsistencies in the hijackers' applications should have raised concerns about why they wanted visas to come to the United States. 15 of the 19 hijackers were Saudi nationals who reviewed visas in Saudi Arabia. Before September 11th, the United States had not established heightened screening for legal immigration or terrorism by visitors from Saudi Arabia. At a joint inquiry hearing, Director of Central Intelligence George Tenet described a less than rigorous review of visa applicants in Saudi Arabia before September 11th. Quote, most of the young Saudi hijackers obtained their U.S. visas in the fall of 2000. The State Department did not have a policy to stringently examine Saudis seeking visas before September 11th because there was virtually no risk that Saudis would attempt to reside or work illegally in the United States after their visas expired. U.S. Embassy and consular officials do cursory searches on Saudis who apply for visas, but if they do not appear on criminal or terrorist watch lists, they are granted a visa. Thousands of Saudis every year are granted a visa as a routine. The majority are not even interviewed. The vast majority of Saudis study, vacation, or do business in the United States and return to the kingdom, end quote. Consistent with this description of the situation, the Joint Inquiries Review confirmed that prior to September 11, 2001, only a small percentage of visa applicants in Saudi Arabia were interviewed by consular officers. Travel agencies were used to deliver visa applications to consular officers in Saudi Arabia, and a relatively low standard was applied in scrutinizing visa applications for accuracy and completeness in Saudi Arabia. The 19 hijackers received visas at consular offices abroad in concordance with routine procedures. The majority of the hijackers sought new passports shortly before applying for visas. Requests for new passports could stem from theft, loss, or accidental destruction. However, terrorists often try to hide travel to countries that provide terrorist training by acquiring new passports. Multiple entry visas were issued to the hijackers for periods ranging from 2 to 10 years. 18 of the 19 received a B1, B2 visa for tourist and business purposes. The 19th hijacker, Hani Hanjour, was issued a B1, B2 visa in error. He should have been issued an F1 visa for study in the United States because he had expressed a desire to study English here. Recognizing the error, the Immigration and Naturalization Services issued Hanjour an F1 visa when he arrived in the United States. As their ports of entry, the hijackers were issued stay visas, which are valid for 6 months. Some hijackers, like Mohammed Atta, Hani Hanjour, Marwan al-Shehi, Khalid al-Midar, and Ziad Jarrah, entered and re-entered the United States for several 6-month periods before September 11th. They stayed for 5 or 6 months, went abroad for weeks or months, re-entered the United States, and received additional 6-month stays. Since the majority of the hijackers were Saudi nationals who received their visas in Saudi Arabia, questions have been raised about the Visa Express program, process in many countries that encourages visa applicants to submit non-immigrant applications to be designated travel agencies or other collection points for forwarding to U.S. embassies. In joint inquiry interviews, State Department officials described the Visa Express program as simply an application collection process and not a visa application, adjudication, issuance, or determination system. Visa Express is merely a way of dropping the application off. Travel agencies assist by giving applicants correct forms, helping non-English speakers fill out those forms, and collecting fees. Approximately 60 embassies and consulates throughout the world use travel agencies or other businesses in this manner. The Visa Express program in Saudi Arabia began in May of 2001. 5 of the 19 hijackers applied for visas in Saudi Arabia in June, so it is likely that they used travel agencies to acquire application forms and deliver them to the embassy. None of the 5, including Khalid al-Midar, was on a watch list at the time. Thus, when name checks were performed, the system showed no derogatory information. If derogatory information did exist in the system, as was the case with a suspected terrorist who applied for a visa in Saudi Arabia in August 2001 under the Visa Express program, the watch list system should resist issuance of a visa. State Department officials informed the joint inquiry that the Visa Express program was terminated in Saudi Arabia in July of 2002 because news reports suggested that the program allowed Saudi applicants to skirt the normal process. According to State Department officials, the program did not affect the number of Saudis interviewed because applicants are selected for interviews when their applications present signs of an intention to immigrate. These officials said that all applicants, including those delivered to consulate officials under the Visa Express program in Saudi Arabia, were checked against a watch list. The joint inquiry also received information from the Immigration and Naturalization Service about the 19 hijackers, 2 of whom, including Nawaf al-Hazmi, had overstayed their visas. In addition, Hani Hanjour had been issued an F1 visa to study English, but did not register for classes and therefore became a non-immigrant status violator. The INS was not aware of these violations until after September 11th.